So according to UNCITRAL model law, there are certain grounds for setting aside an award. As a further measure of improvement, the model law lists exhaustively the grounds on which an award may be set aside. This list essentially mirrors the provision that is contained in Article 36.1, which is taken from Article 5 of the New York Convention. So the grounds that are set out are in two categories, and it has to be proven by the parties if there is a lack of capacity of the parties to include an arbitration agreement, or if there is a lack of a valid arbitration agreement, lack of notice of appointment of arbitrators. Yes, there are like so many other grounds that are included.
Given then that impartiality and independence of the arbitrator is a key characteristic that underpins the legitimacy of arbitration as an acceptable dispute resolution mechanism, what do these terms actually mean? The meaning of independence and impartiality are closely linked. However, there is a distinction. Baroness Hale of Richmond in Gillies versus Secretary of State for Works and Pensions Scotland put it succinctly. Impartiality is not the same as independence, although the two are closely linked. Impartiality is the tribunal's approach to deciding the case before it. Independence is the structural or institutional framework which secures this impartiality, not only in the minds of the tribunal members, but also the perception of the public.
The IBA rules. So why do we talk about this soft law? The truth is that they serve as a benchmark. They've had wide adoption, dealing with evidence to help guide both tribunals and counsel on what to expect in the proceedings. And so it provides that bridge, often what soft law does, to fill in gaps as needed. Interestingly, the IBA rules here, they're applied both in the commercial and the ISDS context. Take into consideration that the IBA rules were introduced first in 1999, then updated in 2020, and a lot can happen in a span of 10 years, as we look also then to any revisions that will be forthcoming. We talk about, in general, ideas of admissibility of evidence, this notion that it's up to the arbitrators, that the tribunals have discretion.